You represent the good and the humble people of Chama South constituency in Eastern Province. You are welcome.
Good afternoon, witness. My name is Sibeso Kakoma Sefulo. I'm Member of Parliament for Mwanji constituency in the Western Province and a member of the Select Committee. Thank you.
Secretariat.
Good afternoon, Chair and other honorable members. I am Chirimboy Elijah from the Office of the Clerk of National Assembly. Thank you, Chair.
Good afternoon. My name is Doreen Mukwanka from the Office of the Clerk.
My name is Mambweka Omanube from the Office of the Clerk. Good afternoon.
Permanent witness.
Good afternoon, Honorable Chair, Honorable Members. Good afternoon, ZLDC. My name is Achawezi Chirwa from Ministry of Justice, sitting in as a permanent witness.
Thank you, Chair, and good afternoon. Good afternoon, witness. My name is David Mwengwa, Parliamentary Counsel from Ministry of Justice. Thank you. Thank you very much. Zambia Law Development Commission, I would like to, before conferring you with immunity, introduce myself. I am Imango Amnyima, Member of Parliament for Nalolo constituency in Western Province, and privileged to chair by my colleagues. ZLDC, we welcome you and we confer you with immunity under Cap 12, which is the National Assembly Powers and Privileges Act, the same immunity which members of Parliament enjoy on the floor of the House, that exempts you from prosecution for what you say. So, witness, you are free to make your submission. The same law applies in the reverse. If you mislead this committee, you may proceed and make your submission. Witness, just for guidance, would like you to focus on the salient features of your submission, particularly straight to the analysis and recommendations of the proposed amendments, so as for us to be able to have time to engage. And be advised that these proceedings are public and are live on Parliament Radio, TV, and on Facebook. You may proceed and make your submission.
Thank you, Chair. Thank you, honorable members. Chair, this is just to notify you before I start that we have two colleagues from the research department that will be joining us, and our sincere apologies for coming in late. We are just coming off another media engagement and that overran in schedule. Thank you, Chair, for your welcoming remarks, and I will immediately proceed to our submission, highlighting the salient features as requested. And perhaps just by way of context, to just recognize that Zambia has undertaken quite a number of constitutional review processes, and following the presentation made by the Honorable Minister of Justice, Princess Kasume MP, where she presented a ministerial statement in Parliament on the 26th of March, she outlined the roadmap for the constitutional review process in detail, and there were 13 thematic areas for the proposed reform as highlighted in our report. And so I will not highlight these one at a time, but just to mention that in that ministerial statement there was reference to the fact that the proposed amendments were non-contentious, and we thought that it is important that we highlight the fact that the words non-contentious suggests that the proposed amendments are not likely to cause any controversy or disagreement amongst the public. However, this assessment can only be validated through demonstrable consensus amongst stakeholders, and it is also important to note that several of the proposed amendments involve fundamental changes in key areas such as governance, which by their very nature may raise some differing views. That, as it may be, our submissions are based on a review of the various documents presented by the previous constitutional review processes, and we've also had a chance to look at a few countries, particularly Rwanda, the United Kingdom, Kenya, and South Africa. And in our submission, we have given a basis for selecting these particular countries. We've also relied on key statistical data that speaks to alignment, delegation, and divergence as highlighted in the document. And so that is the methodology that we took. And in getting into the analysis of the proposed amendments, we will start with the amendment of Article 47, which is referring to the electoral system. And in the structure of the entire document, we look at what the legal text is, the analysis of the amendment, the recommendations of the Constitutional Review Commission, and the technical committees that have preceded the ones that are currently working on Bill 7. And we have looked at relevant case law as well as comparative study of the countries that we have referred to. Our immediate analysis of Article 47 shows that the current constitution uses a majoritarian system for Zambia's elections, and the National Assembly elections following the first past the post model, where the candidate with the most votes in a constituency wins. While this system ensures direct accountability between representatives and voters, it often leads to imbalanced outcomes that marginalize smaller parties and groups that are underrepresented. So the proposed constitutional amendment introduces a mixed electoral system. It maintains the first past the post system for constituency-based MPs who will continue to represent the constituencies. However, it also introduces a proportional representation for additional MPs, which is aimed at enhancing the participation of women, youths, persons with disabilities, hopefully amongst others. The number of proportional representation seats that a party gets will be based on the number of votes that they receive at an election, whereas the current framework prizes simplicity and decisive outcomes. The proposed amendment recognizes the representational deficits of the first past the post system and seeks to mitigate them by guaranteeing space for underrepresented groups. The result is a more complex electoral architecture which seeks to balance constituency level accountability with procedural fairness. And our recommendation, Chair and honorable members, is that even if we do have all these previous commissions that recommended that the electoral system be constitutionally entrenched to ensure stability, legitimacy, and protection from arbitrary political changes, this justification helps to the justification for this entrenchment was to uphold democratic principles and insulate the system from manipulation and foster public trust. We recognize that the amendment that has been made or that is being proposed will enhance representation of underrepresented groups, and the proposed amendments follow the recommendations from the different reports that we have highlighted in our submission by suggesting the introduction of the mixed member proportionate representation electoral system. While the amendment is a step in the right direction, it is still weak because it can be easily changed for political reasons, among other reasons, as it does not include key details. The entrenchment of these details should be included in the Constitution as the supreme law, which will not be subjected to flexible amendments like other pieces of legislation. So that is our recommendation with regard the proposals to Article 47 or to Clause 47, Chair. And we have presented, like I mentioned, the best practice from other jurisdictions that can be learnt. With regards the repeal and replacement of Article 51 on independent candidates, we find that under the current Article 51A of the Zambian Constitution, independent candidates must have severed party membership at least 2 months before the election, even though eligibility is formally assessed at nomination. And we have seen also that there's been court cases like the Muhali George Imbwai versus Enoch Mundia of 2018, and the more latest case of Governance Elections Advocacy Research Services Initiative of Zambia versus the Attorney General and another. And in there, the dilemma that independent candidates find themselves in if they want to participate in an election is that the 2 months required by the Constitution must be prior to the election and not prior to nomination stage. So when the nomination is closed, the candidates are then not able to participate. We also acknowledge that there has been an increase in participation by independent candidates in the Zambian context, although very few of them have actually proceeded to participate in ultimately. And in the submission we recognize that the number of independent candidates has risen from 5% of the political aspirants in 2016 to 8% in 2021, yet only 4% of those independent candidates have secured seats, underlying the structural hurdles that they face, according to a report that has been published by the Electoral Commission of Zambia. In this regard, we recommend, Chair, that the Mwanakatwe and the Mwanakatwe Mungonde and the Technical Committee led by Justice Anil Salungwe recommended that the right of independent candidates to participate in elections be constitutionally entrenched, with the candidates to participate in elections being with equal treatment for party affiliated candidates. So not distinguishing in how we treat party affiliated candidates to those who are independent candidates. The amendment aligns with the recommendation of both the review commissions and the technical committee. By changing the required party membership period from 2 months before election to 2 months before nomination, it addresses the interpretive issues raised in the court cases that I earlier referred to concerning Article 51. I will proceed, Chair. To look at the repeal and replacement of Article 52 on the nomination procedures. The current Article 52 of the Constitution applies the nomination procedures only to the office of the President, the members of Parliament and Councillor, excluding the offices of the Mayor and Council Chairperson. The proposed amendment seeks to extend the procedures to cover the nomination of mayors and council chairpersons. This provides greater clarity on the nomination process for these offices. Further, the amendment clarifies that courts or tribunals handling challenges to candidates' nominations must not only hear the case but also issue a decision within the 21 days. Currently, the provisions provide only for the time within which the court should hear the matter. This removes ambiguity and ensures timely resolution of nomination disputes. Further, Chair, the amendments provides that if a candidate resigns or is disqualified, the election will proceed without restarting the nomination process. The candidates who resign or are disqualified are also prohibited from standing in the same election. In the case of a candidate's death, the election will be cancelled and fresh nominations will be required. Currently, in all such cases, elections are cancelled and fresh nomination processes are then conducted. Our recommendation in this regard is that while the Monacatwe Constitutional Review Commission raised concerns about the high frequency of by-elections, which were often triggered by political defections and resignations, the Commission recommends that the Electoral Commission of Zambia should explore mechanisms to limit unnecessary by-elections and minimize the financial burden that they impose on the country. However, the recommendation was more about improving the process rather than eliminating it altogether. So the Mungomba Constitutional Review Commission did not specifically advocate for the elimination of by-elections, but it highlighted the frequency and the cost of the nature of by-elections, especially following the resignation or disqualification of elected officials. Chair, with your permission, I'd move on to Article 57, that is the repeal and replacement of Article 57 on by-elections for an independent member of Parliament, an independent mayor, a council chairperson, or a councillor. In this regard, we note that the current Article 57 of the Constitution requires by-election whether there is a vacancy in the office of a member of Parliament, a mayor, council chairperson, or councillor. However, the proposed amendment revises this by stating that a by-election will only be held if the vacancy is for an independent member of Parliament holding a constitutional-based seat, an independent mayor, a council chairperson, or a councillor. The amendment aligns with the proposed changes to Article 47 that I earlier alluded to, which introduces proportional representation seats for members of Parliament. For proportional representation seats, the need for a by-election will be eliminated, as parties will have the ability to propose a new candidate for the seat. However, the amendment acknowledges that a re-election will be necessary for positions held by candidates elected under the first-past-the-post system, in line with the existing procedures. It also provides clarity in terms of what happens when a seat held by an independent candidate becomes vacant, which the current constitution does not. In the Monacatwe Constitutional Review Commission and the other commissions, particularly Mungomba, Silungwe, and they recommended that the vacancies for independent members of Parliament, mayors, council chairpersons, or councillors should be filled through by-elections held within 90 days of the vacancy. However, they also advised that no by-election should be conducted within 180 days of a scheduled general election. In addition, the Mungomba Commission specifically emphasized that by-elections should not take place during the final 6 months before a general election in order to prevent electoral confusion and duplication. The Technical Committee drafting the Zambian Constitution of 2012 to 2013 adopted the earlier recommendations and further proposed that an election for the independent office holders should follow transparency and publicly announced schedules with notice given at least 30 days in advance. This committee also reaffirmed the need to prohibit by-elections 180 days of a general election to ensure consistency and efficiency in the electoral administration. Given the amendment, Chair, to Article 57, It is recommended that Zambia adopts a 90-day time frame for conducting a by-election when a vacancy occurs. This aligns with international best practice, such as those in Kenya and Ghana, as shown in our written submission, which set a clear timeline for by-elections to ensure the timely restoration of representation without excessive delays. And this recommendation also mirrors the Monakatwe, the Mungomba and the Sulunga Technical Committee's emphasis on the need for efficiency in filling the vacancies. The amendment should maintain the provision that no by-election should occur within 180 days of a general election, as stated in the proposed Article 57(2). This restriction is consistent with practices in Ghana, where by-elections are restricted if a vacancy arises close to a general election. This not only ensures cost efficiency or effectiveness, but also avoids voter fatigue, which could undermine the legitimacy of the broader election process. It is essential, Chair, that the Electoral Commission of Zambia establishes clear guidelines on which vacancies for proportional representation seats will be handled. Since these seats do not require by-elections, political parties should be allowed to propose new candidates from their existing party lists. Legislative framework should be established to ensure this process is transparent and accountable, preventing any manipulation of the nomination system by political parties. Given the financial burden given the financial burden that frequent by-elections place on the state, it is recommended that Zambia implements strategic measures to reduce the frequency of these by-elections where possible. This includes adopting measures such as internal party dispute resolution mechanisms and reducing vacancies that arise from intra-party conflicts. A cost-benefit analysis must be conducted regularly to assess the impact of by-elections on national resources and identify ways to minimize the financial strain on the Electoral Commission of Zambia. Furthermore, Chair, in order to promote fairness and non-discrimination, candidates belonging to political parties should also be considered in by-elections for the replacement of a vacant position of a Member of Parliament. With regards to Article 58, the repeal and replacement of Article 58 on constituencies, wards and delimitation, the proposed amendment clarifies that the number of constituencies will match the number of MPs elected through the first-past-the-post system to represent those constituencies. It refers to Article 68A, which states the number of MPs that will represent constituencies. It is essentially a drafting issue, Chair, and we thus recommend that Article 58 clarifies the relationship between the number of constituencies and the number of constituency-based seats in the National Assembly, aligning it with a shift to the mixed electoral system. The adjustment ensures that the number of constituencies reflects not only those areas represented by members of parliament elected through the first-past-the-post system as outlined in Article 68A. The Commission supports this amendment as it appropriately adapts the constitutional framework to the new parliamentary structure. With the introduction of proportional representation seats, which will not be tied to specific constituencies, this amendment ensures that the allocation of constituencies remains focused on those MPs elected through the first-past-the-post system, maintaining clarity and consistency in the electoral process. The amendment does not impact the allocation of proportional representation seats which are based on party lists and are not tied to geographical constituencies. Regarding the repeal and replacement of Article 68 on the composition of the National Assembly, Chair, under the current constitution, the Assembly comprises of 156 directly elected MPs, up to 8 nominated MPs, typically appointed to represent special expertise or regional balance, and 5 ex officio office holders, that is the Vice President, the Speaker, and 2 deputies. This structure combines direct public representation with some appointed members to help fill gaps in expertise or representation, while also supporting continuity through key leadership roles. In contrast, the proposed amendment radically expands the Assembly to 211 directly elected MPs, reflecting population growth and a commitment to finer geographical representation. It then introduces 20 additional seats reserved for women, allocated by proportional representation under the new Article 47 2B. Notably, the bill's replacement text makes no direct provision for nominated members or ex officio office holders, suggesting either their reallocation to another article or an intention to curtail executive and speaker appointments in favor of a wholly electoral model. Analytically, the amendment proposal prioritizes gender inclusivity through the proportional representation, addressing the long-standing underrepresentation of women in Zambian politics. At the same time, it upholds full electoral legitimacy by excluding nominated seats, thereby limiting the executive influence over the composition of the Assembly. However, the omission of the Vice President and Speaker from Article 68 could raise interpretive questions. Will they remain automatic members, or must their roles now be inscribed elsewhere? Clarity in drafting will be essential to avoid institutional ambiguity. Finally, on this subject, Chair, the increase from 156 to 211 constituencies signals an effort to enhance local access and reduce members of parliament's workload, but it also imposes a high logistical and financial demand on the Electoral Commission of Zambia. Our recommendation is that, looking at the Mwanakatwa Constitutional Review Commission, the Silungwe-led Technical Committee, and the 2015 Electoral Reform Technical Committee, all of these urge the National Assembly's composition be constitutionally defined, with a limited number of presidential nominees, mandatory gender quotas, at least 30% for women, and parliamentary oversight to ensure accountability and inclusivity. The proposed repeal and replacement of Article 68 instead increases the first-past-the-post seats from 156 to 211, adds up to 20 women, 12 youth, and 3 persons with disabilities under a new proportional representation tier, and doubles nominated MPs from 8 to 10 without gender requirements or oversight mechanisms, thereby diverging sharply from past recommendations by expanding executive discretion rather than constraining it. The amendments introduce novel provisions that depart from the recommendations of the Mwanakatwa Commission, the Silunga Technical Committee, and the 2015 ARTC. While these review processes advocate for a committed number of presidential nominees, gender quotas, at least 30% of women, and parliamentary oversight to ensure accountability and inclusivity, the amendment doubles the number of the nominated MPs. None of the gender requirements, as earlier stated, have been taken into account, and it provides no oversight mechanisms. I will move on, Chair, to our next reviewed article, which is Article 71, on the nomination of election to the National Assembly. The proposed change in Article 71, Chair and Honorable Members of the Committee, introduces the phrase constituency-based seat to clarify the eligibility requirements for parliamentary candidates. Specifically, it provides that a candidate contesting a constituency-based seat must be supported by at least 15 members registered as voters in the same constituency. The change aligns with the proposed mixed member electoral system provided in the amendment to Article 47. The proposed amendment provides clarity in the nomination process and reduces ambiguity as to which clause applies to which candidate. In terms of our recommendations, we are cognizant of that the Mungomba Constitution Review Commission recommended that candidates must pay prescribed fees and must be supported by at least 15 members. These should be registered voters. In 2015, the ERTC proposed that candidates must pay the prescribed fees and be supported by at least 15 registered voters, and a verification period was also recommended. The amendment is not novel, but partially adopts existing recommendations from the Mungomba Commission and the 2015 ERTC, which proposed a nomination fee and the support from 15 registered voters. While these elements are included in the Constitution, the amendment omits the constitutionally mandated verification period recommended by ERTC, and this reflects partial alignment rather than innovation. As no new principles are introduced, only a key procedural safeguard is left to legislation. The amendment clarifies, Chair, that a candidate contesting a constituency seat must be supported by at least 15 registered voters. This ensures a strong local accountability and aligns the recommendation with the past constitutional review commissions. Similar systems promote local illegitimacy, such as Germany's requirement for direct seat wins to access proportional representation. Zambian case law, like Ngwimu versus Kakoma, underlines the importance of fair and credible nominations, while Lumina versus the Attorney General supports candidates' rights in multi-party system. The amendment improves clarity but omits a verification period as previously recommended. The proposed amendment introduced greater clarity and precision by specifying the required support of at least 15 members. The effective implementation of this amendment, Chair, is that for the effective implementation of this amendment, the Electoral Commission of Zambia should establish clear and verifiable procedures for confirming constituency-based nominations. The list of nominators submitted by a candidate must be strictly verified against the constituency-specific voter registration, using digital systems where possible to detect ineligibility or ineligible nominators or inconsistencies. Nomination forms should be standardized, requiring nominators to declare their constituency, NRC number and voter ID, and should include a clear attestation clause. Public awareness campaigns should be undertaken to inform both candidates and the voters of the new requirements, helping to prevent disqualification or helping to inform both the candidates and the voters of the new requirements, helping to prevent disqualification due to technical errors. Additionally, election officials and returning officers must be adequately trained to apply and enforce these requirements fairly and consistently across all constituencies. This approach will safeguard the authenticity of local support and reinforce the integrity of the constituency-based elections. With regards the amendment of Article 72 on the vacation of office of a member of parliament and dissolution of a political party, the proposed amendment provides that an MP will lose their seat on any of the grounds of disqualification in the Constitution. It further introduces a procedure for filing a vacant constituency-based seat. The change requires that political party that originally sponsored the MP who vacated the seat to elect someone else to take over. Currently, Article 72(2) provides for the grounds on which an MP may lose their seat. Article 72(2)(h) provides that an MP can lose their seat if they are disqualified by a decision of the Constitutional Court. Our recommendation, Chair, regarding this particular provision is that the proposed amendment to Article 72 revises the grounds for vacating a parliamentary seat and introduces a mechanism allowing political parties to replace MPs without holding by-elections. While it retains positive aspects such as permitting MPs to remain in office if their party is dissolved, it removes the crucial safeguard of judicial confirmation before an MP loses their seat due to expulsion. This change contradicts the consistent recommendations of the past constitutional review bodies. Allowing parties to appoint replacements undermines the first-past-the-post system by weakening the direct link between voters and their representatives. In the regional best practices that we have highlighted for Kenya, Ghana, and Nigeria, they support by-elections for all vacant seats to maintain voter sovereignty. While expanding judicial recourse beyond the Constitutional Court is a positive step, the overall amendment raises concern about democratic accountability and legal certainty. The amendment in its current form should not be supported. Removing judicial confirmation for expulsions opens the door to partisan abuse and undermines the electoral legitimacy. Replacing elected MPs without a public vote further erodes the accountability under the first-past-the-post system. To protect democratic principles, the amendment must firstly reinstate mandatory judicial confirmation for expulsions, secondly require by-elections for all vacant constituency seats, and thirdly clearly define disqualification grounds in the Constitution. Without these changes, the amendment risks weakening constitutional safeguards and the will of the electorate. Regarding amendment of Article 73 on the petition of the election of a member of Parliament, the current Article 73(2) of the Zambian Constitution provides an election petition challenging the election of a member of Parliament must be heard by the High Court within 90 days, but it does not explicitly require the court to determine or conclude the case within that period. This omission creates confusion about the roles of the courts in resolving nomination disputes by omitting to impose clear obligations not just to hear such matters but to resolve them within the provided time frame. The proposed amendments, Chair, addresses this procedural gap by adding the phrase "and determined." thereby ensuring that both the hearing and final decision are completed within 90 days. This clarification promotes judicial efficiency, upholds the principles of timely electoral justice, and strengthens democratic accountability. We therefore support this in our recommendation. I will move on, Chair. And honorable members of the House, to Article 81, which refers to the term and prerogative of Parliament. The proposed amendment changes the timing of when the term of MPs begins and when Parliament is dissolved. Under the current Constitution, MPs serve a 5-year term, beginning on the date they are sworn into office, following a general election, and ending when Parliament is dissolved, which is 90 days before the general election. The amendment maintains a 5-year term before changes when the term starts and ends. The term will now start on the date that Parliament first sits after a general election, and Parliament will dissolve on the day before the general election. Further, while remain in existence during the final 90 days, it will not carry out any official business such as parliamentary duties during that period. The amendment also adds the words "and determined" after "here," clarifying that when the President submits to dissolve Parliament before the Constitutional Court, the court must not only hear the case but also decide on it within 7 days of the matter being submitted. Lastly, the amendment proposes that during the 90 days when Parliament is not carrying out any official business, the President may recall the National Assembly if the country is at war or facing a state of emergency. The Monacatwe Constitutional Review Commission recommended that Parliament's term and prorogation procedures should be constitutionally defined to ensure stability. The amendments do not introduce any novel constitutional principles. Instead, they either omit, delegate, or partially adopt existing recommendations from the past review bodies such as Monacatwe and the 2024-2025 ERTC. It is found, Chair and honorable members of the House, that the amendment addresses and resolves issues such as issues of ministers remaining in office after the dissolution of Parliament, which was previously clarified through case law, effectively curing procedural uncertainties. Case law has emphasized the necessity for public officials to strictly comply with the constitutional provisions concerning tenure and execution of public functions, a principle that remains sufficiently reinforced by the proposed amendment. The amendment retains the 5-year parliamentary term but redefines its commencement and conclusion to begin on Parliament's first day. The members of Parliament do not receive gratuity during the final 90-day period. The issue of gratuity can be administratively addressed without requiring Parliament to remain undissolved for the full 3-month period. Therefore, aligning the parliamentary term strictly to a 5-year cycle is a necessary reform that should take precedence over attempting to delay dissolution for personal or financial considerations. To strengthen democratic governance and uphold constitutional integrity, it is recommended that Parliament be strictly aligned to a 5-year term, which clear start and end dates. Procedural matters such as gratuity should be addressed through administrative measures, and Parliament should be dissolved on time to prevent misuse of public resources and ensure a fair and transparent electoral process. Without this, Chair, it risks undermining parliamentary autonomy and democratic accountability. Amendment of Article 103 on the election petition. We found that the amendment of Article 103 by adding the words "and determined" to the court's function in election petitions addresses a critical procedural gap or ambiguity that may have existed previously. In legal jurisprudence, the power to hear a matter implies the ability to receive evidence and arguments, but it does not always explicitly confer the authority to bring the matter to a conclusive resolution. The inclusion of the words "and determined" unequivocally grants the court the power to make a final binding judgment. Without this explicit clarification, there could be potential ambiguity regarding the court's conclusive authority, which might lead to prolonged disputes and challenges to the finality of electoral outcomes. The fact that 2019 bill also aims to revise the period for hearing and determining petitions suggests that the efficiency and finality of these processes were already identified as areas needing legislative attention. In this regard, Chair, we recommend that Article 103 clarifies that presidential election petitions must both be heard and determined within 14 days. This addresses the legal uncertainty, as earlier mentioned, and as was seen in the case of Hichilema and another versus the Attorney General, where the lack of clarity over what happened within the 14-day window led to constitutional disputes and delays. The amendment brings Zambia's legal framework in line with best practices in Kenya and Nigeria, where election petition timelines are clearly and constitutionally mandated to prevent power vacuums and preserve the public trust. However, while amendment improves clarity on the determination of the deadline, it simultaneously removes all other procedural safeguards such as filing timelines, admissibility rules, public transparency measures from the Constitution. These are instead delegated entirely to ordinary legislation. This approach directly opposes the recommendations of the Mwanakatwe Commission and the 2015 ARTC, both of which called for these procedures to be constitutionally entrenched to preserve electoral integrity and judicial independence. With 0% alignment and 100% delegation, the amendment risks weakening the robustness and certainty of presidential petition procedures. The amendments to Article 103 should not be supported in its current form. While it successfully clarifies that presidential petitions must be determined, not merely heard within 14 days, it undermines the constitutional certainty by shifting all key procedural details to legislation as earlier submitted. Instead, the Constitution should retain essentially procedural elements such as filing deadlines, judicial oversight mechanisms, admissibility standards, and public access requirements. Entrenching these provisions would ensure consistency, enhance transparency, and protect against arbitrary changes that could erode public confidence. A structured amendment that both clarifies timelines and constitutionality, safeguards core petition process, would better reflect expert guidance and international best practice, thereby strengthening Zambia's democratic institutions. With regards to the amendment of Article 116 on the ministers, currently the Constitution under Article 1163 provides for grounds upon which the office of the minister becomes vacant. The proposed amendment strengthens the principle of electoral fairness and levels the playing field during the general elections. The Monakatwe Review Commission and the 2015 ERTC both recommended that ministerial appointments, qualifications and tenure should be clarified, should be clearly defined in the Constitution to enhance accountability, reduce executive overreach and promote transparency. These proposals sought to limit the number of ministers, establish qualifications and require parliamentary oversight. The amendment to Article 116 ignores the recommendations of these bodies. It removes constitutional provisions on ministerial regulation and fully delegates all matters, appointments, qualifications and responsibilities to future legislation. These changes prioritizes legislative flexibility but sacrifices entrenched accountability mechanisms. Chair, I will move on to the amendment of Article 117 on the provincial ministers. Both the Monakatwe Commission and the 2015 ERTC urged that the Constitution explicitly sets out provincial ministers' duties, appointment procedures and qualifications to ensure transparency, accountability and effective provincial governance. The repeal and replacement of 117 marks a significant departure from prior reform commissions' calls for constitutional clarity on provincial ministers. Commissions like the Monakatwe and the Mongomba emphasize the need for constitutionally anchored appointments, defined roles and accountable mechanisms to prevent excessive centralization and ensure provincial autonomy. Instead, the amendment leaves all these critical elements to ordinary legislation, which is more susceptible to change and to political interference. We recommend, Chair, that the amendments to Article 117 introduces a new rule requiring provincial ministers to vacate office 90 days before a general election. While this is meant to promote fairness in preventing misuse of public resources during campaigns, it overrides existing grounds for vacancy and omits crucial constitutional provisions recommended by past review bodies. Despite the repeated calls from the Monakatwe, Mongomba and Silungwe review processes for constitutionally defined roles, functions and accountability mechanisms for provincial ministers, the amendment delegates all such details to ordinary legislation. The amendment should not be supported in its current form. While the 90-day resignation rule promotes electoral fairness, the total delegation of key governance provisions to legislation undermines constitutional oversight. With regards to Article 149, I beg your pardon, Chair, provinces, districts and wards, the addition of the words electoral before the boundaries in Article 149(7) suggests a move towards greater specificity and enhances legal clarity in the delimitation process. Without this qualifier, the term boundaries could be open to broader interpretations, potentially referring to administrative, geographical, or other forms of demarcation not directly related to electoral purposes. By explicitly stating the electoral boundaries, the amendment removes the ambiguity and precisely focuses the article on the delimitation of constituencies for voting purposes. This precision is particularly relevant given the bill's overarching objective to implement the delimitation report from the Electoral Commission. The delimitation process itself has historically been a point of contention and has raised concerns regarding the transparency and inclusivity. The amendments to Article 149 should be rejected in its current form. While it correctly aligns the electoral boundary functions to the Electoral Commission, it dangerously removes parliamentary oversight over the creation or division of administrative units. This change promotes executive overreach, weakens decentralization, and contravenes both local reform guidance and international democratic best practice. A balanced approach would retain the Electoral Commission's role in electoral boundaries while requiring parliamentary approval and public consultations for administrative changes to ensure accountability, transparency, and align with the constitutional reform goals. We have inserted here some of the findings that we have made in this regard from Kenya, Nigeria, and South Africa on how they have dealt with this delimitation challenges. With regards amendments to Article 153, which is on election of councillors, composition of council and their tenure, the current Article 153 establishes a councillor's election under Article 47(3) by district resident voters, and composes each council of elected councillors, a mayor, and a council chairperson as per Article 154, and up to 3 district chiefs chosen by their peers. It sets out eligibility criteria, exclusion of MPs, a minimum age of 19, a grade 12 qualification, citizenship of valid residence, and a tax clearance, and allowing non-voting invitees to participate in deliberations. Councils serve 5-year terms from the swearing in of councillors to the dissolution of Parliament. Under the proposed amendment clause, originally cross-referencing and Article 47(3) is updated to Article 47(4), reflecting renumbering elsewhere, and a new paragraph is inserted to include a member of Parliament for each constituency within the district as an ex-officio councillor. Existing paragraphs on mayors, chairpersons, and chiefs are merely renumbered, preserving their roles but signaling a closer tie between national and local representation. Honorable members, Article 153(6), definition of a 5-year term, is slightly refined. Instead of running from councillors swear-in, it now begins at the first council sitting after a general election and still ends the day that Parliament is dissolved. Crucially, the bill introduces a new clause prohibiting councillors from sitting or conducting business 90 days before the general election, instituting a formal pre-election blackout to guard against last-minute decision-making that could influence electoral outcomes. In comparison, the current constitution prioritizes electoral mechanics, eligibility, and a straightforward term defined, while the proposed amendment fine-tune procedural timing, strengthen links between the district MPs and the local councillors, and embed a clear pre-election hiatus. The result is a constitutional framework that balances continuity and representation with safeguards against the executive action or council business too close to elections. The recommendations of Monakatwe Constitutional Review Commission that a local government election and council compositions should be constitutionally provided for. A similar proposal was made by the 2015 ARTC The Silungwe Technical Committee also recommended that the local government elections and council composition should be constitutionally provided for. The amendment delegates these provisions to legislation, reducing constitutional protection and risking politicization. While the proposed amendments maintain the existence of local government within the constitutional text, it weakens the protective framework by allowing future parliaments to alter key governance structures, qualifications, and electoral frameworks through simple legislative action. This shifts risks politicization of local government, particularly during election cycles. Thus, the amendment reflects a partial, inconsistent adoption of prior recommendations and fails to institutionalize the checks and balances long advocated by Zambia's own constitutional development history. I will move on, Chair, to look at the repeal and replacement of Article 154, which in part has been cross-referenced to the previous submissions that I made regarding the mayor, deputy mayor, the council chairperson, and the deputy chairperson. The legal text corrects the reference to the part of the Constitution that talks about council elections. It also introduces qualifications for mayor and for council about council elections. It also introduces qualifications for mayor and council chairpersons to be eligible to contest for elections. It then removes the term limit of 2 terms of 5 years for the mayor and the council chairperson. Currently, under Article 154, the Zambian Constitution provides for the election of mayors and council chairpersons through a direct vote and mandates that their deputies be elected internally by councillors with a 2/3 limit, a term limit of 5 years each. Our recommendation on this article, Chair, is that the proposed Article 154 embodies the Mungomba Commission's vision of devolved local power and directly elected mayors and council chairpersons by constitutionally entrenching clear eligibility criteria: Zambian citizen, a minimum of 21 years of age, grade 12 certificate, voter registration, and asset disclosure, formally typing electoral procedures in Article 47(4). This builds on the 2011 to 2013 Technical Committee's precise legal drafting that informed the 2016 Constitution, thereby enhancing transparency, accountability, and democratic legitimacy at the local level. The amendment also corrects the procedural cross-references to council elections, strengthening legal coherence. However, it removes the existing 2-term limit, absent compensating checks, introduces a novel risk of entrenched incumbency. Overall, while the reform significantly clarifies structure, qualifications, and electoral processes in line with the past expert guidance, it should be balanced by reinstating term limits and other safeguards to preserve the leadership and prevent power consolidation. On Article 158, on the vacancy of the office of mayor, council chairperson, or councillor, the proposed amendment introduces a procedure for filing a vacancy in the office of mayor, council chairperson, or councillor. The procedure requires a political party that sponsored a mayor, council chairperson, or councillor who vacated the seats to elect someone else to take over. Chair, the person shall serve for the remainder of the council's term. It further states that to qualify for election as a mayor, council chairperson or councillor to fill a vacancy, a person must meet the same requirements that have been set out in Articles 153(4) and 154(2) of the Constitution. However, no one may be elected to any of these positions within 180 days of a general election. The Technical Committee drafting the 2011 to 2013 Constitution promoted direct elections and by-elections to fill political office vacancies, including councillors, mayors, and chairpersons through the will of the electorate. The replacement of Article 158 introduces a clear process for filling vacancies in local government, but departs from earlier democratic principles, while it ensures timely replacement and continuity by allowing sponsoring political parties to replace without a by-election. It removes the electorate's role to choosing their representatives, which contrasts with the Technical Committee's call for public by-elections. Though efficient, this shift reduces direct democratic participation at local level and could weaken accountability. With regard to amendment of Article 159 on local government elections tribunal and petition, currently our Zambian Constitution does not provide a clear understanding on the role of the local government elections tribunal in resolving election petitions. The proposed amendment, however, introduces the words "undetermined" after the words "heard," clarifying that once an election petition to nullify the election of a councillor is submitted to a local government's elections tribunal, and the petition must not only be heard but also be determined within the 30 days. This reduces any misunderstanding that may occur in terms of the role of the local government. The Technical Committee emphasized time-bound, efficient, and complete resolution of election disputes at all levels of presidential, parliamentary, and local elections. It sought to remove ambiguity in judicial and quasi-judicial functions, making it clear that institutions must not only hear petitions but also deliver binding judgments within legally set timeframes. The amendments to Article 159(4), honorable members, which mandates the local government election petitions be both heard and determined within 30 days, thus aligns with the recommendation of the Mungomba Constitutional Review Commission and the Technical Committee. With regard to Article 176 on the Secretary to the Cabinet, the Mungomba Constitutional Review Commission of 2003 advocated for a merit-based appointment while also encouraging reforms that ensure inclusivity and efficiency in public administration. One of the focuses of the Monakatwe Constitutional Review Commission was professionalism and efficiency in public service. It recommended that appointments to top public offices, including Secretary to the Cabinet, should be based on competence, experience, and integrity, but it did not fix rigid experience thresholds. This created space for future reforms like reducing the required years of service to enhance flexibility and respond to changing administrative realities. The Technical Committee on drafting the Constitution 2011 to 2013 advocated for clear yet flexible qualification criteria for public officers, aiming to streamline the requirements and avoid excluding capable individuals while maintaining the standards of competence and experience. The amendment to Article 176 reduces Reducing the required experience for the secretary to a cabinet from 10 years to 5 years aligns with the Mungomba and Monakatwe commissions, which support merit-based but inclusive public service appointments. It is also consistent with the technical committee's effort to streamline the qualification criteria. The proposed amendment, therefore, reduces the required experience while broadening eligibility and lowering the professional standard expected. It is recommended that the Constitution should retain clear, constitutionally enshrined qualifications for the Secretary to the Cabinet to uphold professionalism and institutional independence, rather than reducing the experience requirement and delegating the appointment criteria solely to legislation. The Constitution should maintain a higher experience threshold, such as the original 10 years, to safeguard the integrity and effectiveness of this office. Embedding these provisions constitutionally would promote good governance and protect the office from undue political influence. With regards amendment of Article 178 on the vacancy of the office of the Attorney General, the deletion of paragraph B of Article 178(1) removes the previous requirement for the Attorney General's office to become vacant upon change of president. This amendment aims to ensure continuity in this crucial legal advisory role during the transition period, preventing a potential legal vacuum. Our recommendation in this regard, Chair, is that while the amendment aims to ensure continuity in the Attorney General's office during presidential transitions, it is recommended that the Constitution explicitly provides clear procedures, timelines, and safeguards the vacancy and removal of the Attorney General. Embedding such provisions constitutionally would strengthen the office independence and transparency, protecting it from potential politicization. Reliance solely on ordinary legislation risks undermining institutional stability and may expose the role to executive influence without proper checks. Therefore, the amendment should be accompanied by constitutional safeguards to uphold the principles of professionalism and continuity in Zambia's highest legal office. Our last substantive provision, Chair, has to do with the Office of the Solicitor General as provided for in Article 179. Under the 2016 amendment, Article 179(4)(b) provides that the Solicitor General's tenure automatically ends if another person assumes the office of President. In other words, a change in presidency, whether by election, death, resignation, or removal, triggers the vacation of the Solicitor General. This results in the Solicitor General serving at the pleasure of the incumbent head of state. By contrast, Bill 7 of 2025 explicitly deletes this ground of vacation. Removing paragraph B severs the automatic linkage between the presidential turnover and the Solicitor General's tenure, so that the change in president no longer displaces the office holder. The subsequent paragraphs, formerly C and D, are renumbered but remain in force. These typically cover another standard vacancy triggers such as death, resignation, incapacitation, or misconduct. One of the recommendations of Mungomba Constitution Review Commission Chair was to strengthen the independence of legal officers and lessening of political interference in public services. The technical committee drafting the 2011 to 2013 Constitution also advocated for professionalism, depoliticized legal roles, which includes the office of the Solicitor General. amendments to Article 179(4), which removes the automatic vacancy of the Solicitor General's office, aligns with these particular provisions. It also promotes institutional stability and professionalism. The amendment stops short of fully securing the Solicitor General's independence by omitting constitutionally entrenched safeguards such as clear removal procedures based on competence or misconduct rather than political shifts. By delegating these crucial details to ordinary legislation, which can be changed by a simple parliamentary majority, the amendment leaves the office vulnerable to future political interference and undermines the very stability and impartiality that it aims to protect. And therefore our recommendation in this regard is that the proposal aligns with the long-standing recommendations of past reform bodies. However, while the amendment enhances legal stability, it does not go far enough. The reform lacks accompanying constitutional guarantees to fully protect the office of the Solicitor General from political manipulation. The mere removal of the automatic vacancy clause without additional institutional safeguards leaves the office vulnerable to executive overreach. To address this gap, the Constitution should expressly establish a transparent, merit-based appointment process. This process should include competitive selection based on demonstrable legal experience, vetting by an independent body such as a Judicial Service Commission, and final appointment by the President subject to parliamentary ratification. Such a structure would bolster the office's credibility, reducing executive capture and fostering public confidence. Further, it is recommended that the Solicitor General's service serves a term of 5 years, renewable once, with removal from office restricted to clearly defined constitutional grounds such as gross misconduct, incapacity, or breach of law. This removal process should involve an independent inquiry or tribunal, thereby shielding the office from arbitrary dismissal by the executive. To enhance independence, the Constitution must explicitly state that the Solicitor General operates independently in discharging the legal duties. The office should be aligned with public interest and with the Constitution, not on partisan directives. It is also necessary to establish the administrative distinctiveness of the Solicitor General from the Attorney General, with clear constitutional provisions on when the Solicitor General may act independently, particularly in instances of conflict of interest. Comparative lessons from countries like Ghana, South Africa, and the United Kingdom, as highlighted in our report, will show that legal continuity across political transitions can be preserved through constitutional or statutory safeguards. These jurisdictions demonstrate that protecting legal professionalism and stability is essential in upholding the rule of law and promoting sound governance. In conclusion, although the proposed deletion of the automatic vacancy clause is a step in the right direction, it must be situated within a broader constitutional reform agenda. It is recommended that Zambia embed critical protections related to independence qualifications, tenure, removal procedures directly within the Constitution rather than relying on ordinary pieces of legislation. Chair, I will end here. This is not to say, Chair, that the amendments to Article 266 on definitions are not important, but I think they're self-explanatory in our own submissions, and we are open to questions from the Honorable House. I submit, Chair. Thank you.
Thank you, Zambia Law Development Commission, for your copious submission, very detailed. Honorable members, you are now free to seek points of clarification with the witness. If any, if we are happy with the witness, unless if you propose a 5 minutes break. Was it a long, was it too much load? Yeah, Honorable Ngandu, make a submission.
Before that, Chair, you remember what I had proposed earlier, where I said instead of witnesses giving us the entire submission, looking at how technical and detailed some of these submissions, this is what I anticipated. It's very, very important that probably if we cannot make follow-up questions on each article, we should at least maybe do it at maybe two articles recommendation, then we make a follow-up, unlike the way it is where you are bunched with a whole lot of information, then you ask to make a follow-up. Looking at this, I would propose, since you are requesting for a break, probably we go for a break 5 minutes so that members can refresh, because this has been a long presentation. Then thereafter we can make follow-up points of clarification and questions, if any. I submit, Chair.
Okay, thank you. Thank you, Honorable Ngandu, for submission. Guidance will be given. Honorable Kambita.
I have a slight different view to Honorable Mwangandu's submission, not really to downplay his submission. I believe the submission by the Law Development Commission has been comprehensive, and not just comprehensive, it provides recommendations. So there's clarity in the articles they are referring to, which they wish to comment on. They have commented on them, of course, with the backing of case law, including good practice, reference to good practices, international practices, and have made their recommendations on the basis of the issues. So to me, the whole process on each one of the articles they have commented has taken that approach, and so it's very clear. It's up to us now as a committee to chew the cud. We need to comprehensively read this during this process for purposes of the input that will go into our report. At this point, if we seek any further clarifications, they are a stone throw away from us, and I think engaging in this fora just for the purpose of fulfilling scripture would be really just consuming time. I submit.
Okay. Well noted, Honorable Kambita. Honorable Nkombo, you had an intervention.
Thank you very much, the Commission. I want to thank you particularly for the manner you've presented your paper. It makes it very easy for anyone to understand where you stand. It is not ambiguous. It is extremely clear, to me at least, because you have been very systematic and methodical to make it easy, where you even give case studies and examples of best practices and countries that have applied such law. And where you disagree, you have also been unambiguous. You've been very clear. So I tend to agree with Honorable Kambita, where a presentation gives clarity, maybe we should be given a chance to digest. And after digestion, if there are any questions, we can then, through the clerk, send them over to you, and then you can summarize those that we may not understand in the manner that we all intend to understand, because you are making submissions really of where you stand. Okay? The question I would have, however, before I finish, is just find out if during this process the parent ministry or sponsoring ministry, Ministry of Justice, did consult with you on each of these clauses.
Thank you. Just to give guidance, so just guidance that we proceed to interact with the witness, and I think Honorable Kombo, so we won't take a break. And if it's a question.
I just wanted also.
No. For guidance, you will not react to each other as members. So if it's a question, yes.
It's a valid concern, Chair. We
No,
are a
honorable
committee.
member.
Do we need to receive submissions in camera?
No.
Points of clarification, or for the benefit of the public and those following us. It's very, very important that I don't know, Chair. I've already submitted.
Okay. Okay, witness immunity is lifted. We adjourn for 5 minutes. You'll be called back. Thank you.
Good afternoon. Thank you very much for watching Parliament Television. That was a submission by the Zambia Law Development making a submission to the Select Parliamentary Committee appointed to scrutinize the Constitution of Zambia Amendment Bill, National Assembly Bill number 7 of 2025. And the committee has since taken a short break. They will resume after 5 minutes. And we look at the object of the Constitution of Zambia Amendment Bill number 7 of 2025. The object of this bill is to amend the Constitution of Zambia so as to 1. Revise the composition of the National Assembly to provide for the increase in the number of constituency-based seats from 150 seats to 211 to actualize the delimitation report by the Electoral Commission. B, to revise the electoral system for the election to the National Assembly to provide for a mixed member proportional representation electoral system to guarantee the representation of women, youth, and persons with disabilities. C, to revise the provision relating to fitting of fresh nominations on resignation of a candidate. D, revise the provision of relating elections. E, revise the number of nominated members of Parliament. F, harmonize the term of Parliament and Council to achieve a 5-year term. G, provide for a vacancy in the office of Provincial Minister and Provincial Minister 90 days before a general election. And H of this bill is to remove the 2-term limit for office of mayor and council chairperson. And I of the bill seeks to revise the composition of the councils to include members of parliament holding constituency-based seats. And J of this proposed bill is to revise the qualification for appointment of the office of the Secretary to the Cabinet. And K of this proposed bill is to provide for the Attorney General and Solicitor General to continue in office after a general election and until a new office bearer or new office bearers are appointed. And L is to revise for the definitions of the words child and adult and provide for the clarity on the period within which an election petition shall be concluded. And N of this proposed bill is to provide for the matters connected with or incidental to the foregoing. So those are the objects of the proposed Constitution of Zambia Amendment Bill, National Assembly Bill number 7 of 2025, and the Parliamentary Select Committee has since been put in place, and this was as announced by the Honorable Madam First Deputy Speaker in the House on Tuesday, 2nd December 2025, and the Honorable Madam Speaker did remind the House that the consideration of the Constitution of Zambia Amendment Bill number 7 of 2025 was deferred on 26 June 2025, and this was in line with Standing Orders 121.1, which states that a member who sponsors a bill may defer or withdraw the bill at any time by formally writing to the Speaker stating his or her decision. And Madam Speaker did say that, however, she noted that the Standing Order 121(1) also provides that a bill that has been deferred for a period exceeding 6 months is deemed withdrawn by a member sponsoring the bill. And in this regard, she informed the House that she had received communication from the Honorable Minister of Justice indicating that the Minister now seeks that the House immediately resumes consideration of the bill, and to this effect the Select Committee that was constituted to scrutinize the bill would commence its meetings immediately, and hence the commencement of the meetings today. And this Select Committee comprises a number of members of Parliament, both from the ruling party and the opposition. So it's chaired by an Alolo Member of Parliament, Mr. Wamunyima Imanga, and others include Jacqueline Sabao, who is the Vice Chairperson of the committee. We also have Sibeso Sefulo, Mr. Garin Kombo, Mr. Newton Samakai, Brian Kambita, and Mr. Mubita Anakoka, and as well as Stanley Kakubo MP. Others include Mr. Davison Mungandu MP, Mr. Simon Banda MP, Ms. Wongile Mwamba MP, and also Jonathan Daka MP, as well as the George Kandafula MP, Mishek Nyambose MP, and Mr. Emmanuel Banda MP. So that is the composition of the Select Committee that has been constituted that has been appointed to scrutinize the Constitution of Zambia Amendment Bill, National Assembly Bill number 7 of 2025. So the meetings of the Select Committee will continue until sometime next week, and we'll continue giving you updates as the meetings continue sitting. And with to this effect, the meetings will continue actually on Saturday, which is tomorrow, and Sunday. So 5 and 6 December 2025, the meetings will continue as they continue receiving reports from the various stakeholders that they will be interacting with, and this will all be live on both Parliament Television and Parliament Radio, as well as all our social media platforms, which will be available to give you updates as the meetings go on. So that is what is happening right here at Parliament Buildings. The Select Committee is sitting to scrutinize the Constitution of Zambia Amendment Bill, National Assembly Bill number 7 of 2025. And just now, we take a break. We come back as the meeting continues sitting. Keep watching.